Hi everybody, welcome back to Social Media Law and Risk Management. I really hope you're enjoying the course so far. This week we're looking at the courts and social media. We're into Module 2 and into our second lecture. Your textbook reading this week has been Chapter 3, See You in Court. Don't forget there's all of that supplementary material there as well. The material that comes from the chapters of my latest book that I've written with Mark Polden, the 5th edition of the Journalist's Guide to Media Law. 5,000 words a week there of extra material if you choose to extend your understanding of any of these areas. What we cover today is your learning problem, and we've flagged that last week at the start of the module. We look at the court's use of and tolerance of social media. We look at the principle of open justice versus secret trials and how that feeds into social media. We consider suppression orders or gag orders, contempt of court, the different types of contempt, contempt in the face of the court, disobedience of a court order, scandalising the court, the area of sub judice or prejudicial publicity about a trial, and juror revelations. And we look at social media that can be used as evidence against you. Of course, we finish off with a few discussion questions for you to workshop on the discussion board. Let's look at that learning problem again. And you'll see that you'll remember that it was all about the hotel website in Lobster Cove. I guess the question in relation to this week is, if that goes to court, what sorts of areas of contempt of court might apply to that scenario? If it becomes a defamation case, for example, and how might it be reported in those situations? What might you be able to tweet or blog, microblog on social media about the case if it is in the civil courts as a defamation case? So there are the basic normal questions that we ask each week. And we link it both to the area of the law, which is mainly this time defamation, and the stakeholders who are involved. All right, well, let's get into the content of courts, and we start with courts' use and tolerance of social media. And I use the expression ancient justice rules for a wired generation. And when we were talking about the justice system earlier, we were saying it's hundreds of years old and it's finding it hard to adapt to social media. Well, that's true also of the courts themselves. The courthouses, the bewigged judges, these are all 17th, 18th, 19th century phenomena. And what we have is a 21st century communication medium, and they don't necessarily always match up that well. So one area we've found that has been with journalists attempting to tweet from the courthouse in the early days of Twitter. And traditionally, courts have banned devices, cameras, recorders. Even journalists in previous, last century weren't allowed to do anything other than take their shorthand notes in court as just a special privilege. Well, in 2009 in Australia, in the famous double INET case, which is an internationally famous copyright case based out of Sydney, the judge there allowed two journalists to tweet from the courthouse, which was historic in this country. There'd been a little bit of tweeting from court happening in other parts of the world, and the textbook explains how that emerged in the US and the UK as well. Since then, we've found much more growing tolerance of Twitter in the courtroom. In fact, the image you can see there on this slide is the Supreme Court of Victoria's Twitter handle. And you can see they actually joined Twitter in February 2011, and they're quite active in the Twitter sphere as a public relations tool. And you'll find that happening by court information officers internationally throughout different court systems. So they've really embraced that medium. Unfortunately, other people have been jailed for using social media in court, and the textbook talks about some very sad examples of those. We've also had various journalists warned for using social media in court without the permission of the courtroom. Most courts now have policies allowing the media use. In recent years, in Australia, for example, both Victoria, New South Wales and South Australia have developed social media policies for the courtroom. They typically involve some small delay in the proceedings so that journalists who are in the courtroom are allowed to tweet, but after, for example, 15-minute delays where the court has the time to suppress information if they feel that that should be done before the information is released on social media. What this is an example of is the principle of open justice, which stems back through centuries. And the default position in most Western democracies, evolving from Britain, is that open justice implies that the courts should be open to the public unless there's some very, very good reason for them to be closed or for material not to be published about them. Now, the text gives examples of those situations where there might be good reasons for the court to be closed. Sometimes it's to protect the privacy of an abuse victim, perhaps a child. Other times it could be because of an important national security issue, and we don't want the secret to get out, which might alarm the public or perhaps add to the threat. Or it could be someone's life that's in danger as a witness, for example, a protected witness. So the court needs to be closed and perhaps the information suppressed for those reasons. But at an international level, the basic default position should be that people are entitled to a public trial under Section 11 of the Universal Declaration of Human Rights. And human rights and legislative instruments internationally reinforce that. That said, there can be various gags imposed by a court, suppression orders placed on certain parts of a proceeding, or sometimes even the whole proceeding. In fact, the notion of a super injunction applied by a court arose in the UK as a controversy over the past few years, mentioned in your textbook, but a super injunction even bans the mentioning of the fact that an injunction has been issued. So it is a genuine gag. In both the Ryan Giggs and the WikiLeaks cases in recent years, Ryan Giggs is mentioned in your textbook. It showed how social media can come into play because an injunction was issued in the Ryan Giggs case. There he is, the footballer there in the slide. It was a private matter. There was some extortion allegedly going on against him. It was purportedly to do with his marital fidelity. It involved a reality TV star that he was alleged to have had an affair with, but it was all top secret. There was an injunction issued by the court over it. But the secret got out on social media. And at one stage, the authorities were even threatening tens of thousands of Twitter users with contempt action for breaching the suppression order. More recently in Australia, we've had a super injunction issued to do with a very important trial which alleges fairly bad behaviour on the behalf of certain foreign leaders within the Asia-Pacific region. WikiLeaks jumped online through social media and through its website and broke the injunction. They were publishing it from beyond the Australian jurisdiction, so there wasn't much that could be done about it. But the word was out who these foreign leaders were that were allegedly engaged in criminal behaviour. That's the difficulty of injunctions and courts and that combination with social media. Another big controversy has been in Australia and other countries, particularly the US, the UK, Canada, the rollout of special national security powers. If you look on Twitter at the hashtag #NatSec, you'll see this debate taking place regularly about proposed national security laws internationally. Well, in Australia, there have been special powers granted to national security government agencies to force the closure of certain court proceedings and to suppress certain material under terrorism laws. Contempt of court is the breaking of those sorts of laws, but it's much more than that. There are several categories of contempt. A basic definition is any behaviour that can interfere with the administration of justice. And there are 5 main areas of contempt that might affect you on social media. One is contempt in the face of the court, where you do something bad in the courtroom. And that might be using social media in the courtroom when that's not allowed. Another is disobedience contempt, where you disobey an order of the court. A judge might order that you not publish something and you go ahead and tweet it. Well, that's a disobedience, and you can be fined or perhaps even jailed for contempt for doing that. Another is called scandalising the court, which is where you publish something particularly denigrating about a court and the judicial process. It's not just defamation of a judge, because a judge could sue you for defamation. It goes further than that. With scandalising the court, it would be material you publish that erodes the public confidence in the judicial system. Sub judice contempt is a really problematic area for social media. And my colleagues and I have done a report on this to the Standing Council of Law and Justice nationally. It's since changed its name, but it's to do with social media and jurors. Because jurors, the argument goes, can be influenced by social media posts about accused people facing celebrity trials or very big profile trials over serious crimes. We've had several of these in Australia in recent years where there has been the potential for social media conversations to damage the presumption of innocence against high-profile accused. Normally, it has involved people posting previous offences by the accused, previous character material, and perhaps witness statements about the accused, all of which are banned under sub judice rules once someone has been arrested. And the final area is revealing the deliberations of jurors, and that is an offence. In Australia it certainly is. The US, though, has a much more liberal approach to jurors and what can be said about them. In fact, many jurors in the US even sell their stories about their deliberations in celebrity trials. So there's a different set of rules in place there. The contempt has been applied quite famously in quite a few cases now where jurors and others have broken the rules of social media. And we detail these in that report that I mentioned, and the link to that's available on the site, called Social Media and Jurors. But the Joanne Frail case is a particularly famous one that's mentioned in your textbook, where she was a juror and she actually friended the accused on Facebook. And that became known to the judge, and she was jailed for a few months as a result of doing that as a juror. Well, the final big area that the textbook covers is social media in the court system, as far as whether people can access material about you and use it as evidence against you. And we all know that that's being done these days. We know that our Facebook profile, the photographs we post there, the messages we post, the times and days and places that we've posted them from, all become a trail of evidence that is now being accepted by the courts in litigation. It could be in the family court where a former partner is trying to collect evidence against you, perhaps over the custody of children. It could be to do with a heinous crime that someone has committed. It could be various threats that they've made on their social media account to the victim. In all sorts of contexts, it's being used as a fertile ground for litigation and prosecutors. Courts are accepting social media material as evidence, and they're granting orders to lawyers as part of the discovery process to go back and find earlier versions of social media that might have been erased. They're allowing them to make demands of platforms. We look later at whether the platforms are obliged to reveal it, but it seems that quite often the platforms are revealing some of this material voluntarily. So, and the courts are even allowing in some places for court documents to be served using social media, so that someone is made formally and legally aware of a particular process against them because they're active on social media, and the courts in those cases are accepting that social media delivery or serving of the documents is an acceptable process. Well, our discussion questions this week drill down into all of those areas. So what are the pros and cons of letting people tweet or post to Facebook from the courtroom? Have we entered an era where it's impossible for courts to control the flow of information, and they should look at other means of controlling what jurors know and understand about a trial? Perhaps better training of jurors. What other solutions can be used to prevent this bias of jurors as a result of reading social media postings? So what really appears anachronistic now amongst the court rules and processes that don't gel well with social media? And what points from this topic might be worth building into an organisation's social media policy as you work towards a critique of such policies at the end of your semester? Where have we been today? We've learned about this principle of open justice, that the courts should be open unless there's some good reason to control them. We've learned that social media allows a big opening of the courts, but the courts are having all sorts of problems with that. And we've had a particularly close look at contempt of court and how that can be triggered by social media postings. Where are we heading? Well, next week we're going to take a pause to get together to look at our learning problem. There'll be no formal lecture next week. It'll be a workshop that we'll be holding online about your learning problem. And after that, the following week, we'll move into Module 3, looking at identity, privacy, and confidentiality. In the meantime, get on the discussion board and get prepped up for our workshop next week on your learning problem. And part of that prep is to talk about these discussion questions we've just floated with you, and for you to take some notes on all of this for your learning journal. Well, I'll see you in a couple of weeks, but we'll workshop next week. Bye for now.